Welcome back everyone. Today I'm going to review this book, Supreme Whispers, Conversation with the Judges of the Supreme Court of India 1980 to 89 by Abhinav Chandrachud. This book is about the secluded and antisocial lives of many judges of the Supreme Court of India and the politics that goes on in the court among judges. The author of the book is Abhinav Chandrachud. He is a practicing lawyer at the Bombay High Court. He belongs to the illustrious legal family of the Chandrachuds. His father, Justice D.Y. Chandrachud, is a sitting judge of the Supreme Court of India, and his grandfather, Justice Y.V. Chandrachud, was the longest serving Chief Justice of India for 7 years. He himself is very distinguished as he studied from Harvard as Dana Scholar and Stanford University, where he was a Franklin Family Scholar. And he is author of some other very good books like Republic of Religion, Republic of Rhetoric, and A History of the Bombay High Court. Now let's talk about the book. The book is based on interviews conducted by Professor George Gadbois, who was an American scholar and professor and was hugely respected by the judges of the Supreme Court, and that was the reason that he was able to persuade almost every judge of the Supreme Court till 1989 to give him an interview, and he took very extensive handwritten notes of every interview that he conducted. These interviews spanned from 45 minutes to some hours, and these interviews were quite frank, and they revealed a lot of things because the judges talked about the court and a lot of them talked about their colleagues and the controversies that happened. And the author was a mentee of Gadbois, and that is the reason that Gadbois, just before his death in February 2018, gave these notes to the author and didn't impose any condition as to how the author could use it. So the author studied them and turned them into a book. I would say that this book is the gossip journal of the Supreme Court of India, where you realize that after all judges are also humans and they do not fall from heavens, and they also indulge in personal rivalries. Now let me read something from you from the book. In an instance, the wife of a Supreme Court judge, S.C. Roy, told Gadbois that after her husband was appointed as a judge to the Supreme Court of India, the Prime Minister of India, Indira Gandhi, asked him to take care of some legal work concerning her family property in Allahabad. And when that judge died, soon after being appointed to the Supreme Court, some officers of the government came and whisked those files away so that nobody would know about this. Chief Justice Bhagwati told Gadbois that a law minister, also a senior advocate, once feigned a heart attack to get an adjournment in the Supreme Court so he could appear in Delhi High Court to argue a matter. Gadbois was told by Chief Justice Pathak that a sitting judge of the Supreme Court was against the appointment of Delhi High Court Chief Justice Chawla to be appointed to the Supreme Court because Chawla, who was that judge's neighbor, had threatened to shoot one of his dogs once. Some of the contents of the interviews were off the record and most have never been written about, not even in the monumental book that was written by Gadbois. He didn't write about these interviews because these judges had placed faith in him and told about a lot of things. And if these things would have been made public 30 years ago, when all of them were the sitting judges at the Supreme Court, it would have created a lot of controversies. But today, so many of them are no more, and it would not create that much of controversy. But it is important for the history to know what exactly happened. So that is why the author has chosen to write this book now, after 30 years. So the author writes, revealing these stories in the 1980s would have been like lighting a spark in a powder keg. Today, however, the keg no longer holds any powder. In a paper that Gadbois wrote, he analyzed the dissenting pattern of the judges. And one of those patterns was that of K. Subba Rao, who was a justice at the Supreme Court of India. When he was a judge at the Supreme Court, he wrote 48 dissenting judgments, which was a record in itself. But once he became the Chief Justice of India, he didn't write even a single dissent, which tells us about the powers that the master of the roster exercises while constituting benches. So this also tells us about that about the fact that a chief justice can easily sit with the agreeable colleagues and colleagues who are like-minded, so that he can deliver judgments he wants. And the author tells about why so many judges also were interested to meet Kurt Boyce for interview, because Kurt Boyce was a scholar in the United States, and that was a time when there was no internet facilities. So these judges maybe wanted some reading material or foreign reading material. So it was easy for them to get that reading material if they had a connection with Kurt Boyce. Some of the judges even asked him during interviews for some book or the other, or one judgment or the other. And some judges wanted to know how their sons can go to the United States for their higher education, or if the university where Gut Boyce was a professor would be interested in calling them for some lecture to the United States. Or one law minister Ashok Sen told Gut Boyce that is there any chance if he could get some professorship in the United States, because he would lose elections in India and he does not see any chance of himself here. So would it be possible if he got any professorship there? So there were some other reasons also that Gut Boyce was very highly regarded in the legal circles, because he also wrote many law reviews in many reputed magazines. Now let's talk about what happens chapter wise. In first chapter, the book is about rivalries of the Supreme Court. There were intense professional, ideological and personal rivalries. In fact, whether it was Chief Justice Sinha and Justice Imam, Chief Justice Gajedkar and Justice Sarkar, or perhaps most famously Chief Justice Chandrachud and Justice Bhagwati. So the author talks about there were often rivalries between the Chief Justice and the senior most judge of the Supreme Court, and this was something that we saw in the press conference that was recently held in January 2018, when the senior most judges, after the Chief Justice, complained that the Chief Justice was exercising his powers arbitrarily. In chapter 2, the author talks about the puzzling lack of dissent in the day-to-day decision making of the court. He says that on personal level there are so many judges who are against each other, but when it comes to the court, why are the judges not writing dissents? Then in third chapter he tells why they don't write dissents. He says that judges are overworked. Over 40% of their productive time goes in hearing special leave petitions. Special leave petitions came from the colonial times. Earlier, what used to happen in colonial times, that if they were not satisfied with Indian courts, some person could, the aggrieved party could approach Privy Council in London, and they could file a special leave petition there. But special leave petitions filing in London was very expensive, and also this jurisdiction was used by Privy Council very sparingly. But to file a special leave petition in the Supreme Court now is very inexpensive, and the Supreme Court uses this jurisdiction very liberally. So it becomes very easy for a person to file an SLP, and that is the reason that these SLPs are being filed in more and more numbers, and this increases the workload of judges. So chapter 4 organizes the decliners, the people who declined to be elevated to the Supreme Court when they were given a chance to be elevated. Because earlier what used to happen, that the Chief Justices of the High Courts were a class in themselves. They thought that if they were to be elevated to the Supreme Court, they would just be a judge, but in their own High Court they are the Chief Justice, and they were also very well paid. But once India became independent, their salaries decreased drastically, and there was no guarantee that one person would stay a Chief Justice of that High Court for till the time they retired. So now more and more judges are accepting elevation to the Supreme Court when they are offered, because anyway there is no guarantee that they will stay in their High Court for forever till their retirement. And also there is also increase in the pay that is given to the Supreme Court judge, but they are still very less. That is the reason that earlier there was this convention in the bar that once you are offered a judgeship, you accept it, because there is statistics in this book that the Chief Justice of Calcutta High Court in the colonial period earned more than a judge in England, while the Bombay High Court Chief Justice drew a salary higher than the Chief Justice of the US Supreme Court. But now it is not so. The salaries are very meager, and it is not it is nothing as compared to the expertise that the judges of the Supreme Court and High Courts have. And that is the reason that now so many bright lawyers, very wise lawyers, established lawyers decline judgeship when it is offered to them. In chapter 5, there is a lot of discussion about the executive interference in the judiciary, and how it is a popular belief that there was no interference in the judiciary between 1950 to 1971. But the author breaks this myth by narrating an incident where Home Minister Sardar Vallabhbhai Patel convinced the Chief Justice of India, Justice Kania, to appoint Justice Bashir Ahmad Saeed to the Madras High Court against Chief Justice's wishes. So during those years also there were some instances in which the independence of judiciary was not paramount. And then there is discussion on the collegium system, how the establishment of the collegium system has changed things. Firstly, it gave the senior colleagues of the Chief Justice of India an institutionalized role in making appointments, which earlier did not exist. Earlier there was only the concurrence of the Chief Justice that mattered. Secondly, it made the recommendations of the Chief Justice of India and his colleagues binding on the executive government, which means that if a recommendation is made, the government has to accept it. Thirdly, it took away the government's power to intimidate judges through transfers, etc. But there is another fact that after the retirement, the judges are appointed as per the whims and fancies of the government, and that creates an impediment to the independence of the judiciary, and that is a matter of concern. Chapter 6 examines the criteria that is followed to appoint judges at the Supreme Court and the High Court level. There's a lot of nepotism involved that is clearly told in the book, and the judges belonging to some religious minorities and backward castes and women are appointed always because they want to maintain diversity. And there's another very important and interesting thing about the privacy concerns, because when a judge is to be appointed, there are intelligence agencies who inquire about if any judge drinks excessively or has some extramarital affairs. So the author says that this does not impact the work of the judge, so why to do it until it does not impact the working of the judge. And then there are instances of political biases of the government in 1970s and 80s. While they were asked to consider someone for judgeship in the Supreme Court and High Court. So I believe that you will have to read this book more to understand all of this, because I find this book to be very, very interesting. When I read this, I could not put it down, and this is exactly what Fali Nariman, who is very eminent lawyer, he also says that this book is unputdownable. And I believe that if you want to know more about the courts of India, you will read this book. Thank you very much for listening to this.